Hi, I'm Jonathan Kappy.
And I'm Rebecca Rauws.
Welcome to Holland Estates. You're listening to episode number 608. And today we will be discussing Bill 245. How you doing, Rebecca?
I'm great. How are you?
I'm good, living the dream,
Yeah.
working in my basement, I'm still practicing
Yeah.
law, so I'm grateful for that.
Yeah, I mean, it's hard to complain when we're still able to do this still from home.
So there are some big changes on the horizon.
Yeah,
We
it's exciting.
Yeah, well, we've got Bill 245, which is introduced in the Legislative Assembly of Ontario, and there are some sweeping changes that are going to affect the practice of estates law, how wills are made, powers of attorney, even affecting rights on intestacy and things like that. So, where are we at in terms of its progress through the legislature?
So it's recently passed through second reading just a couple of days ago on March 2nd, and it's been referred to the Standing Committee on the Legislative Assembly, and the hearings for that committee will be held on March 11th and 12th. So it's moving along at a pretty good pace.
Yeah, well, considering first reading was February 16, that's really moving through. So, why don't we talk about? We're not going to be able to get into everything and all the details, and we encourage anyone who's interested to look it up on the internet. But it looks like it's going to be law, sometime soon. But we do want to hit some of the big ones in terms of the Succession Law Reform Act changes that we're going to see, and if we have time, we'll go to the Children's Law Reform Act and the Substitutes Act.
Right.
So why don't we start with the Succession Law Reform Act? What are some of the big ones that are coming down in terms of changes to that legislation?
So, one of the big ones, which is a temporary measure that we've seen throughout the pandemic, is that the execution of wills using video conferencing is going to become permanent. So, the temporary measures are being added into the SLRA effective April of last year, and then they're making some other slight changes for the permanent version that will come into effect once this bill is passed.
Right. So that's where you've got one witness who is a member of the Law Society,
Right.
and you're witnessing someone sign remotely. You can now witness it remotely. And now we're going to start dealing with signing and counterparts. So now you're
Right.
going to have wills that are multiple pieces of paper, and the legislature is going through what that looks like, what that process is going to look like, and the how that will is going to get probated.
Right. And I mean, we don't do a lot of will drafting, but I have heard from some solicitors that they don't love the counterparts term just because it's kind of cumbersome and you've got like, 100-page document when all is said and done and you've got your multiple versions. But I mean, at the end of the day, it's an option. Once we come out of the pandemic, it won't be maybe as necessary, but it's still there.
Yeah, I think one of the biggest problems comes in terms of what if they're not exactly the same? When I'm, reading this proposed legislation, it talks about, copies of the will that are considered identical, even if there are minor non-substantive differences, if they printed differently in different
Mm-hmm.
printers, if you have one version of Word, another version of Word, and it prints out differently.
Yeah.
So, I mean, that's obviously something that's going to come up. There's no doubt about that.
Mm-hmm.
But counterparts is also, I mean, you've got, you know, I guess it would be simpler if the testator signed and then sent it to the witness who signed that same document, because it keeps things simpler.
Mm-hmm.
But interestingly enough, that one of the provisions and requirements when you do this in counterparts is that the subscribing witness has to be on the video and subscribe contemporaneously.
Yeah.
So you're
Yeah,
both
yeah, that's
basically doing it
interesting.
at the same time at different parts, and you're not sort of circulating it around. So that's something that we'll have to get used to. So, I think the technology has evolved, and people's openness to new technologies has evolved since the pandemic started. And I do think it makes sense to keep this going. And
Yeah.
also it gives people in remote areas better access to services that they need.
Yeah, exactly. It's good to have that flexibility.
So I would say that the biggest change
Mhm.
that I've noticed in what's coming down the pipe is welcome to the world of substantial compliance.
It's
So
exciting.
until now, in Ontario at least, because other provinces have been different, is that there is a prescribed form for wills and how they need to be executed, do execution with subscribing witnesses. And if you didn't comply with the due execution requirements, the will was not valid no matter what the testator's intention was. It now looks like legislation is going to get implemented where a court, where it is satisfied that a document or writing that was not properly executed sets out the testamentary intentions of the deceased or an intention to revoke or alter or revive a will, that a court can make an order that it is a valid testamentary document.
Right. Which is, I mean, it's obviously better to follow the rules if you want to be absolutely certain that your will is going to govern the administration of your estate. But it's nice to have this fallback in the event of an inadvertent mistake or,
Yeah, I think it's fair to say that you never want to have to rely on the substantial compliance rules. But if someone passes away and their will technically doesn't comply, at least there is some remedial provision available to the court to do that. So
yeah, exactly.
So another interesting one deals with how the law is now going to treat spouses. And previously, you were either a spouse or you were not a spouse. And now the legislature is trying to deal with spouses who are separated but not divorced. Do you want to tell us a little bit more about that?
Sure. So there's a definition that's going to be added as to what it means to be a separated spouse. There's a couple of different ways you can get there. One is living separate and apart for 3 years as a result of the breakdown of the marriage. So I guess that ending there was included to avoid capturing people who maybe are living in long-term care homes separately from their spouse, but they're still married and intend to be together. The second way you get there is if you have a valid separation agreement or you have a court order dealing with your rights and obligations arising from a breakdown of the marriage or a family arbitration award. Basically, if there's some kind of concluded
financial
thing.
arrangement.
Yeah.
I think if you've concluded your financial arrangements but don't necessarily have your divorce, you'll be treated as separated.
Right. Now with the changes, separated spouses, they won't be sharing on an intestacy anymore. Whereas if they were not yet divorced, they would still share under the previous provisions.
And I also believe that they're going to be treated as predeceasing, just like a divorced spouse would in a will.
Yes, yeah, you're right, under the section 17. Yeah.
So listen, it is all premised upon a breakdown of the marriage, right? So that's going to be something that will obviously be tested in terms of factually, whether there was an intention to separate because of a breakdown. And but I do think that people are more mobile. I think that long-term care is a great example of times where people don't live under the same roof but still intend to live marriage-like.
Right.
So we'll have to see how the courts deal with that provision.
Yeah, I'm sure we're going to see a lot of this situations where it's not entirely clear.
So I think those were the major changes, at least that I noticed with respect to the Succession Law Reform Act.
Yeah, and then the other one, which is it's not as lengthy of a change, but there's no more revocation of a will by marriage, but that was just kind of like this is repealed, not a huge addition.
So yeah, well, I think that one was designed to go after the predatory marriages.
Mm-hmm.
So if you get married, your will still governs.
Mm-hmm.
Obviously, your new spouse will have certain rights under statute, right. But the will is still going to stand. So I think that was sort of what it was designed for.
Yeah, I think that'll help a lot with those kinds of situations.
So interesting. And so I guess tangentially to what we just talked about in the Succession Law Reform Act, the Substitute Decisions Act is also going to be amended, which will also allow for execution of powers of attorney by video conference in any counterparts too. So that will help. And usually we often see the wills and powers of attorney getting executed at the same time. Mm-hmm. So that makes sense.
Yeah, I agree. It would be kind of counterproductive to have to do the powers of attorney in person by doing wills over video.
And I also think they increased the preferential share, didn't they?
Yes, I think that it's not this bill that would do that, but there was a regulation that increased it, yeah, to 350
Right.
instead of 200.
It's been a long time since they changed it.
Yeah.
So.
It's a welcome increase.
Anyways, I guess, and the last change, which is not as juicy as the ones we've talked about now, but dealing with the Children's Law Reform Act. So it's always been the case where the legislation said that up to $10,000, a child didn't need a guardian of property, and that a parent or whoever had custody of the child could hold and manage that property up to $10,000. So what they've done is they've removed the $10,000 reference in the legislation. They've now said, listen, the regulations will deal with the number, and that way I guess they can change the regulations more easily than they can the statute, presumably because it's going to increase over time.
Right.
And I think they also made one change in terms of, prior to this proposed legislation, judgments or orders of the court where money was payable to children was excluded from that guardianship requirement. And they're now saying that it is now part of the legislation, as are entitlements under intestacy.
Right. Yeah. So that's a good, I think that's a helpful change.
Listen, I think anytime you've got a significant amount of money being owned by a child, having a guardian, having a management plan, having court supervision of that money is always in the best interest of the child. So if it's any money of consequence, you might as well have someone making sure that it's all done right. Because there's, to me, easy opportunities for abuse. And not that most people are inclined to do that, but for the rare occasions
those outliers.
Yeah. So, but I think that concludes our podcast. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
I'm Rebecca Rauws.
Should you have any questions, please email us at webmaster@hollandhull.com or leave us a comment on our blog.
Thanks so much.